Good morning, everyone. This is Johanna Klohn, and welcome to Medico-Legal Considerations in Sleep Medicine. Thank you for joining me this morning. I'm going to go over just two housekeeping rules. I have no conflicts of interest to disclose for you this morning. And also, if you have questions, there is a Q&A button that is at the top, and you'll see the little symbol that says Q&A, and please put any questions in anytime during the presentation, and I'll be happy to answer them at the end of the presentation. And also, I've been asked to remind you that it will be a recorded webinar, so you're welcome to check back at this website to see the webinar again. And off we go. A little bit by way of background for me, I am an attorney here in the state of California, and by background, I'm a clinical scientist licensed years ago in transfusion medicine. I went from working in a laboratory to going to medical school, law school, and then getting my master's in public health at UCLA, where I'm currently the chief risk officer. So I've got a little bit of medicine, a little bit of legal, a little bit of public health background, which brought me to this position today. We're going to start today by talking about just kind of a high-level overview on the types of law, because as we go through how this affects your practice, you'll see that there are different variations on what category a case could fall into. So first, civil liability. Civil liability are the kind of cases that you see where it's person versus person, Mr. Smith versus Mrs. Doe, or John Doe versus Kmart. There are entities involved. And people are seeking in civil litigation is compensation of some sort for a harm. So usually it's for money. On occasion it's for injunctions, you know, please stop using this or please stop doing that or don't destroy this. But as a general rule, as it pertains to medicine, it's compensation that a plaintiff is seeking. If it's not civil liability, it could be criminal law. Criminal law is very different. In criminal law, there are actual rules and statutes, and they're defined by the government, and they try to keep public safe. So things like assault or fraud, those would be considered criminal acts. And there isn't a person versus a person. It is, you see these on TV, right? The people versus the individual, and the individual is the defendant. And the question is, can a physician be found criminally negligent or in violation of criminal law? And the answer is yes. And they're usually pretty extreme cases. And most currently what you'll see is there's a heavy focus on the opioid addiction in the United States, and you will have criminal charges brought against a physician who is breaking written statute and laws. So what do I mean by statute? Well, laws can be made by legislature. They're actually like business and profession codes such and such. They're actual written laws that talk about how we are to conduct ourselves. Business and professions code is something that would be seen often in medical practice. Case law is a little different. Case law comes from courts making decisions. So people bring their civil cases to the court and they set a precedent. And once a precedent is set and ruled on and published, it becomes law through the case. So, you know, an example that made the news, when a same-sex couple wanted a wedding cake from a bakery, they sued civilly. They said, you're violating me personally. You're harming me personally. Eventually, the ruling on that case became law. So we don't need other people to continue to bring that same case. We now know that is the law, and that needs to be followed in that way. Now, people can bring a civil case for harm in violation of that law. So civil and criminal law, those are the basic concepts of the difference as we go through the slides today. How does this affect you as an MD? As a physician, what kind of a role do you play in litigation, either criminally or civilly? Could be several. If you're the treating physician of a patient, you could potentially be the defendant in a civil matter. So the plaintiff patient is suing you, the physician, in a medical negligence case. That's a civil case. They would be looking for money. You could be a mandatory reporter. So you could be required by law to make a report to a governmental agency. That's an actual law, and you are obligated to make those type of reports, and that would be in the criminal realm. Subsequent treating physicians are when you see a patient, but you're not the person involved in the lawsuit at all. You're not the plaintiff, you're not the defendant, but you're going to testify for the physician, for the patient. Or you could be an expert witness where somebody contacts you and says, we need an expert to talk about this specific thing in sleep medicine. And you have an expertise in this, and will you testify, and they'll pay you. And as the slides go on, I'll give you a little bit of a role play in each of these positions that you might potentially play. What I would advise is all physicians should have medical malpractice insurance of some sort and coverage. And if you're asked to play any of these roles, particularly if you're a defendant and you're named in a lawsuit, you want to check with your insurance carrier or your insurance program. If you're part of a health system like I am, and I'm a risk manager, you want to contact your risk management department, because in any of these cases, you want to make sure that you have your coverage from an insurance standpoint, that your attorney that is hired is paid for. So in addition to written statute, there are also regulations you are probably familiar with. There's, when you hear people with OSHA violations, those kind of things, you want to keep those in mind too. Now, I practice in California, so I'm going to give some California examples. CAMEA, which is the confidentiality law for California, it's a sister to HIPAA, and it's the privacy law. You want to consider your medical boards, whatever state you practice in. You want to know your medical board rules, your reporting rules. California has a specific health and safety code. That's a statute that is about lapse of consciousness reporting, so it's very specific to sleep medicine. HIPAA is a national, it's a federal law, so that applies to everybody throughout the country. And really the key to that for a practicing physician is to know that you are only to access and share a person's health information, private health information, to the minimum necessary information you need to care for that patient. So an example would be if a lawyer calls your office and says, oh, I'd like to speak to you about your patient, my client, or not even my client, just your patient, about an incident that happened, a car accident, something outside of your practice. I would recommend never directly speaking to anyone. HIPAA requires that the patient give you permission to disclose their personal health information. So you'd always want to stop and say, I can't really even verify this is my patient, but you need to show me some document that the patient has released me to speak to you about their care. So that's really important. I bring up the ADA because that'll come up later when you're counseling your patients who may need to consider not working in their field or driving or those kinds of issues. They do have some protections under the ADA, and you want to protect your patients. Criminal liability has a much higher standard for being found liable or being guilty. So you can be defendant in a civil case, but in a criminal case when you're a defendant, there are very specific things that fall into the category depending on the charges. Now you want to think about this in two realms, not so much as you as a physician, but start thinking about your patients, what kind of actions your patients may be involved in that is connected to their diagnosis, and then how would they fall into these kind of conduct issues. So mens rea is required for any kind of a criminal act, right? So you have to have an intent for certain criminal liabilities. Now there are lesser criminal liabilities, criminal negligence. That's if a defendant took a very unreasonable risk by not doing something or doing something. A little bit of a lesser charge, reckless. You have conduct where you do not desire a harmful consequence, but you know that something could happen. So if somebody gets into the car after drinking, they don't want to go out and harm someone, but it's common knowledge that if you drive drunk, there's a consequence to that and that someone could get hurt. So we'll talk a little bit about sleep disorder as a defense because that can happen. You may have a patient that is involved in an event and they are going to use their sleep disorder as a defense for the criminal action. So expert testimony, how does expert testimony work? If you're asked to act as an expert, you would want to present objective data based on peer-reviewed published articles. The testimony is to provide a conclusion that the likelihood that the sleep disorder was present at the time of the event. So you may not be a hired expert, you may be the treating physician, and you'll be called to answer some questions of the likelihood that the sleep disorder had something to do with, and you'll be talking about that specific patient. Of course, after a release or with a subpoena or with some kind of appropriate release to be discussing the patient in court, in deposition. An expert for the criminal side or the civil side would also want to talk about the conclusion and say, well, it can or cannot be reached based on this if they're defending the patient or if they're prosecuting the patient. So expert testimony in sleep disorder cases is very powerful. It's going to convince a jury in either a criminal or civil case that this patient knew or had mens rea, or it was connected to their disease, or it was not connected to their disease. And as a physician who treats these patients, you may be called as a subsequent treating physician. As a treating physician, different states have different laws and rules around this when it comes to the criminal side. But again, on the civil side, you would always want to contact your insurance carrier, your defense attorney. You just want to have someone guide you through this process. So some states have something in writing. It is a criminal written statute, like we talked about, and those are very clear. So the state of New Jersey, back in 2003, based originally on a civil case, had a holding that an individual can be found acting recklessly in a vehicular homicide case if driving while knowingly fatigued. Then they made a statute defining fatigue, and that is having been without sleep for a period in excess of 24 consecutive hours. So I will say that as far as I can find to date, New Jersey is the only state that has this specific of a law regarding sleep disorder and driving. Arkansas in 2013 did also come up with a fatigue driving statute. It's described as an offense under negligent homicide. It's punishable by a misdemeanor. So when the driver is involved in a fatal accident and they've been without sleep for 24 consecutive hours, so that seems to be the key, the 24 consecutive hours, or in a state of sleep after being without sleep for 24 consecutive hours, so they can be found punishable for negligent homicide. Most states have not taken this step and actually defined the vehicular laws to be so specific. Civil liability is a little bit different than criminal liability. It requires 4 things to make a case. So you need to have a duty to the person that is the plaintiff. You need to have breached that duty. The breach of duty has had to cause harm, and there has to be an actual harm. So some medical examples outside of a sleep disorder. If someone had had a surgical procedure and there's a retained foreign object, but it is immediately identified, and the patient is immediately, they have never even left the OR, and the patient's reopened, and then the object is removed. So we go through this. Does a surgeon have a duty to this patient medically? Yes. Was the duty breached by retaining a foreign object? One can argue yes or no, right? That's where the experts come in. Well, if it's found right after the count, it's immediately removed, the duty was breached, yes or no. That's where expert opinion comes in. Was there harm? Well, you can define that. Did the extra 20 minutes, 30 minutes in the OR cause harm? Likely not if there's no long-term harm. If there is, was it caused directly by that breach of duty? So that's how you break down a civil case and a medical case. Now, what if there is an appendicitis case, comes into the emergency room, not diagnosed, patient goes home, comes back 15 minutes later, there's no rupture, there's no harm. And the patient sues and says, well, you had a duty to find that diagnosis, you breached that duty as a physician. Yes, but there's no harm. Coming back 15 minutes later, if there's no rupture, no medical outcome, losing 15 minutes of driving back and forth to the hospital is not a harm. It would be difficult for that person to make a civil liability case. So what if there's a harm resulting from a sleep disorder? Is the physician in any way liable for that harm to the patient, to third parties? Is the patient liable? So we've seen by the previous slides, there are 2 laws for vehicular negligence and criminal action for the patient. if they are not sleeping. Now, they don't say with a sleep disorder, they specifically say for lack of sleep, just fatigued driving. But we are now trying to roll this into what is your role as a physician and the patient's role for fatigue driving or other kind of negligence due to a sleep disorder. So what is your duty as a physician? You have a duty to the patient. You have a duty to the patient to treat them and to care for them. But you also have a duty of privacy, right? You have a patient-physician relationship, and that is sacred. So that is where the rub starts to come in. What do? I'm a sleep disorder physician. I'm concerned about this patient of them driving, about heavy machinery, about what they do out in public. On the other hand, who do I report this to? Do I report this? What is my obligation and my connection to this patient and our relationship and to their privacy? And there's also laws about privacy and when can that be breached? So what about patients that a patient may harm, others the patients may harm? Well, in California, the statute that I mentioned previously actually has language that says if a physician reasonably and in good faith believes that the reporting of the patient will serve the public interest, they may report, and that's very specific to the DMV and to the driving. But what about to an employer? What if your patient is a pilot and you know they have a disorder where they may have loss of consciousness? Do you report that to who? Do you report that to the FAA? Do you report that to their boss? Again, what about privacy versus harm to the general public? So in some professions, and we are all probably familiar with TerraSoft, for psychotherapists or people in psychiatry, there is a law, and this is a case law based on an event that happened. And psychiatrists or people in psychiatry have a duty to warn, to protect a foreseeable victim of violence against them. But again, even the TerraSoft case, it has parameters. So the physician receiving the information has to make a reasonable judgment. So if the patient says very clearly, I've had enough of John Smith, I've bought a gun and I'm going to his house tomorrow. There's a very definitive plan. He's made a very definitive threat. That's easy, right? That's protected by TerraSoft. You call the police, you notify, if you have the information, the potential victim. That's a pretty definitive and black and white threat. Where it gets difficult is what if someone says, I've really been thinking about killing John Smith. He's really been a problem for me. I'd really, I'm thinking about getting a gun. I don't have one yet. Those are a little more gray, and a little more thought has to be put into that. And then there's, of course, I really want to wring his neck. He annoys me. Well, I would say that if on that basis, someone were to make a report to the police and to the recipient, probably then the physician could be found negligent in the fact that they weren't reasonable in their decision to make those notifications. So there's a reasonableness factor that falls into the psychotherapist and the psychiatry privilege with TerraSoft. Now, even though there isn't a TerraSoft law, I think that's going to reflect in sleep medicine as well. So even though there's not a specific law in case, there is this reasonableness factor, and it's not always clear, but that has to be decided when making reports to the Department of Health, motor vehicles, or to another agency, and we can work some of those and talk some of those through. So what is a breach in the standard of care? Well, there's an actual definition, and that's the level at which an average prudent provider for a physician in a given community would practice. It's how similarly qualified practitioners would have managed the patient's care under the same and similar circumstances. So the medical malpractice plaintiff, or in this case, it would be the plaintiff or patient who's complaining about your breach in privacy, must establish the appropriate standard of care and demonstrate that the standard has been breached. And then we also talk about, is there a standard of care for the patient? And as we talked about in the criminal cases, it really has to do with what is in their mind, what will the jury and the judge establish their thought process was when they went ahead with that act. But yes, there is a standard of care for the patient, but certainly there is for the physician, and it is what would someone in your similar situation. So again, you're going to be applying state law. You're going to be applying what people in your profession around the country in a similar situation would do. Now the causation. There has to be that connection between the harm that's caused and the behavior. So that's very tricky for a physician. The causation, if you report someone and they have harm, well, is the causation you're reporting? Is the causation their underlying condition? In a case where a third party is harmed, is the causation the patient's decision-making process? Could it be said that there is causation when the physician didn't report and should have? So the line here is the harm suffered by the plaintiff must be proved to result directly from the negligence of the defendant. Causation must be demonstrated. So that's where the defense is going to come in on the physician's part in the reporting or not reporting. And I think you're getting to see what we're creating here, which is a scale of when do I report, when don't I report. And that is the call that my office receives mostly from our sleep medicine physicians, is this balance of when am I directly causing harm, either by reporting or not reporting. So damages and harm, they have to be real damages and harm. So there are two kinds of damages. There are economic damages that a plaintiff can allege. So a plaintiff can allege they lost money, they lost, or they have medical expenses as a result of the defendant's behavior. There's also non-economic damages of pain and suffering. If you practice in California, non-economic damages of pain and suffering are limited. A plaintiff can only receive in a medical negligence case $250,000. But economic damages are not capped in California. Each state has their own damages laws. And I think it's really important for physicians to know and understand what the laws are in your state as far as damages. And stay in touch with that. There are, like in California, there is a push every couple of years to get rid of the cap on pain and suffering. It's MICRA, M-I-C-R-A is the acronym. And I think it's important for physicians to watch that because your medical societies, your state medical societies can get involved in these things. So anyway, economic damages and harm, I go specifically to the loss of earnings, again, for sleep physicians. If a patient says, you negligently reported me or you negligently revealed information about me, now I can't work. So I can't drive to work, for example. So now I've lost earnings. I'm going to bring a civil case against you for a negligent report that has now harmed me. And that's the concern that people have in sleep medicine. What about regulation? So people say, what do you recommend we do in a case like this? I'm concerned about my patient driving, or I'm concerned about my patient operating heavy machinery. I'm concerned about my patient in the workplace based on what they do. This requires a conversation with the patient. Ultimately, the goal would be if a patient is at high risk and they could potentially cause harm to themselves or others, is for them to not be in that situation. And if you recognize this medically, in the ideal world, it's a discussion with the patient of, I understand you need this job, but the harm that you can cause can do much greater harm to you physically or to someone else physically. And rather than threat of report, discussions and familiarity with things like the Americans with Disabilities Act and saying, look, there are protections for you, or having information in your office that can guide them to legal aid or to social work, or someone that can help them make the decision to self-report or to self-make adjustments or self-make decisions that's in their best interest and others' best interest. That's the ideal way to handle a patient like this. And I know it's kind of, you're thinking about it's easy for you to say, but sometimes physicians don't even try. They kind of get stuck between the, do I need to report or not, and not really working through it with the patient. And that is the key. The best ultimate outcome is a patient-driven safety decision. So, sleep deprivation. Are consequences of sleep deprivation commonly known? Well, they certainly are to your profession, but are they commonly known like to the legislature, for the states? Because as I mentioned, we only have really very few states that have actual legislation around sleep disorders in recognition of this. Well, there's definitely recognition. How they handle it is a little bit different. So if you look at some of the states, there are things like Massachusetts has the second week of November is Drowsy Driving Prevention Week. Or, you know, the state of Utah, their Department of Transportation has studies to determine which highways cause drowsy driving. I know I've been on that highway to tunk. You know, they look at these kind of things. They're aware that sleep deprivation and drowsy driving is a problem. So there are legislative bills on the books, sometimes for years in these states that haven't gone through. And it's something that as an organization, physicians in this specialty should really look at and become involved with, because once legislature is passed, it does make your job easier. There are black and white instructions for you to follow. You know, are sleep deprivation issues known by the general public? I don't think so. I don't think, not as commonly, obviously, as drunk driving or some of these other issues are. And that's why many states have these kind of pushes where it's, you know, in Texas, November 6th to 12th is Drowsy Driving Prevention Week. So there isn't a push to make people more aware of this, but I don't think it's as known by the general public. And it would be helpful if it was, because the general public also makes up our jury system and feeds into the legal system of accountability. But certainly sleep specialists are very familiar with sleep deprivation. And there are so many papers and studies out there about the causes of things that happen as a result of sleep deprivation. And I mean, we look at some of these examples I have on the slide. These are huge worldwide known issues. Chernobyl, the Valdez oil tanker, the Space Shuttle Challenger. I mean, excessive hours, while admirable, raise serious questions when it jeopardizes job performance, particularly when critical management decisions are at stake. And I think we've seen this even in the medical field, right? It used to be very admirable and almost an initiation for residents to have them working days and days on end, hours and hours on end. That was the initiation into this difficult profession you've chosen, and its commitment that you're making to help save lives and to treat people. And again, while admirable, in the end was really not serving the purpose it was intended to serve, and actually put patients and the physician trainee at risk. So these things are being understood now more and more. So here's the very lengthy and long California reporting requirement. I'm certainly not going to bore you and read the whole thing to you, but it gives you an idea how committed California is to the reporting requirement with the DMV and the Department of Health. On the second slide, I should go back and just point out one thing. Here's the language I talked about earlier. If the physician, it's at the end, the last paragraph of A, if the physician and surgeon reasonably and in good faith believes that reporting of the patient will serve the public interest, he or she may report the patient's condition even if it may not be required, and there is a list specific. So if they think there's harm, now you go, well, what good does that do? Well, in the second part here, if you look at F, a physician and surgeon who reports a patient diagnosed as a case of disorder characterized by lapse of consciousness pursuant to this section shall not be civilly, so sued by a private person for money, or criminally liable, the state then coming after you criminally, to any patient for making any report required or authorized by this section. So this is called immunity for the physician. And can the patient bring an action against a physician anyway, even if there's immunity by the state? Well, they can, but they're going to have to prove negligence for reporting. And it would be really, really hard to do that. And when someone's acting in good faith in the public interest, that case isn't going to go very far. So in California, anyone can bring a case for any reason, but then the answer is, can they hit those four things we talked about: the duty, the breach, the causation, and when there's an immunity on the books for that state, it would be very difficult to bring this action and take it to the end, because of course the defense is going to bring up the fact that there is immunity, and all these writings are already on the books in statute by law. So The only thing someone could do is come back, as I gave the example earlier. The plaintiff could say, look, no physician in this same position with these same facts would have reported this. And that would be, you know, a really far out thing where someone really, the example I gave with the terrorist off, where someone just, oh, I could just wring his neck and all of a sudden there's a report made. That would be probably considered negligent. But with any other fact supporting you, you would have immunity. And this is by state law. There are immunities under HIPAA as well, which would be the federal law. So Colorado, interestingly, unlike California, they don't have a physician reporting, but they have a self-reporting. And their law reads, drivers should self-report medical conditions that may cause lapse of consciousness, seizures, etc. This is just an excerpt. And physicians are encouraged, but not required to report patients. This is a little different. California requires physicians to make a report when it's known, who have a medical condition that may affect their ability to safely operate a motor vehicle. Colorado also has an immunity for the physician. So same rules apply as far as someone bringing a civil action against you. So patient privacy versus public safety. And like I said, this is the call my office receives the most from sleep medicine physicians. The physician sees a risk, you have the discussion with the patient, you explain to them the risk, and they just disagree. They don't think that they're at risk or they need to keep that job, and they're going to go on and continue with their risky behavior. So now you have to look at what the statutes are in your state, what federal statutes may apply, and you have to look at your privacy statutes, and you're going to start balancing the two. And again, use your insurance program, your risk program, general counsel's office that may work for the organization that you're with to help you balance these, because the people working on the legal side are going to have the best idea that where you practice, what have the cases looked like? Have physicians been defending these? Is there a trend against the privacy defense? And they'll have a better idea of how to help you balance the two. Ultimately, you want to do what ethically and medically is correct for you within the boundaries of being protected by the law. The patient privacy issues are very, very strong, and those are hard things to balance against what might happen to harm someone. So this is actually a quote from this paper, and I'm going to read it because I think it's really profound, which is difficulty of determining the correct balance between the privileges of individuals to pursue their lives as private drivers or operators of workplace vehicles or machinery, and the perceived need for communities to provide a measure of protection for their members against adverse consequences of risky or dangerous behaviors. And that's ultimately the balance that you have to make. It's really tough. So there's some things that are a little bit easier. I'll give you another, recent examples. We've been seeing a trend in patients bringing cases against physicians for the patient behavior, or bringing the patient into the lawsuit. So it can happen two ways, like the Chantix cases. If you watch TV and you see Chantix helps you quit smoking, but there's and also blah, 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 and they give you the 100 lists of side effects. One of the side effects is violent behavior. And patients have brought cases against physicians saying, you prescribed this to me, I did harm to others, I am now in a criminal case, and I, physician, am holding you liable for my costs in that criminal case, or what happens to me for my behavior because you didn't warn me about the side effect. Those cases have not gone very far on the civil side, and I have not seen yet on the criminal side the prosecutors bringing in the physicians for prescribing it. So far, that's how those cases have laid out, and we watch those. So no criminal negligence on the part of the physician has been found that I can find, and plaintiff patients on the civil side have not successfully blamed their physician. It happens in all kinds of medication cases. On the civil side, patients will say, you didn't balance my meds correctly, and I went on a shopping spree, and now you owe me the $500,000 I spent on my shopping spree, or gambling spree, or drinking binge. Those cases, again, in civil law, they have not been published. There may be cases where people settled, but there haven't been any published cases yet where a physician has been held accountable. In California, we had a 2016 case where a doctor was found not liable in a car accident by a dementia patient who had loss of consciousness. But that one, again, was related to a side effect of a medication. So folks have asked me about recent cases in California where physicians have been held liable in civil cases where a third party sued not just the patient, but included the physician. And I've done a search and I cannot find any such case exactly where the physician was found liable by a jury for not reporting a patient and then a third party was harmed. So these things they're fluid, they can change. And again, I think these are very case specific and they're very fact specific. And I encourage you to seek help and to really look and watch what your community, like the American Academy of Sleep Medicine, anything they've published, publications, your state laws, and certainly, whatever resources you have available in your workplace. That's the best advice I can give, because I wish I had a black and white answer, but even when people call and it's fact specific, we really have to work through the privacy and the details of the case. I very much appreciate you all joining me this morning, and everybody please stay safe, and hope to meet some of you at an upcoming meeting. Thank you.